Good afternoon. The hearing on the FOIA in the 21st century, using technology to improve transparency in government. The meeting will come to order. The Oversight Committee mission statement. We exist to secure two fundamental principles. First, Americans have a right to know that the money in Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. We will work tirelessly in partnership with citizen watchdogs to deliver the facts to the American people and bring genuine reform to the federal bureaucracy. This is the mission of Oversight and Government Reform. I'm going to allow myself an open statement. Today's hearing is going to address the transparency in government and on how advances in technology can be used to improve public access to information. This hearing will focus particularly on the Freedom of Information Act, or FOIA, which is the primary tool the public has to get information from their government. Transparency is extremely important, and it is necessary in order to have a government that is accountable to its people. Holding the government accountable and ensuring the public's right to know represent the fundamental missions of this committee. And when President Obama took office, one of his first actions was to release a new memo on FOIA, directing agencies to adopt a presumption of openness. And in a statement to the public, the President said transparency and the rule of law will be the touchstones of this presidency. I would like to play now a short clip of his comments.
But the way to make a government responsible is not simply to enlist the services of responsible men and women or to sign laws that ensure that they never stray. The way to make government responsible is to hold it accountable. And the way to make government accountable is to make it transparent so that the American people can know exactly what decisions are being made, how they're being made, and whether their interests are being well served. The directives I am giving my administration today on how to interpret the Freedom of Information Act will do just that. For a long time now, there's been too much secrecy in this city. The old rules said that if there was a defensible argument for not disclosing something to the American people, then it should not be disclosed. That era is now over. Starting today, every agency and department should know that this administration stands on the side not of those who seek to withhold information, but those who seek to make it known. To be sure, issues like personal privacy and national security must be treated with the care they demand. But the mere fact that you have the legal power to keep something secret does not mean you should always use it. The Freedom of Information Act is perhaps the most powerful instrument we have for making our government honest and transparent, and of holding it accountable. And I expect members of my administration not simply to live up to the letter, but also the spirit of this law. I will also hold myself, as President, to a new standard of openness. Going forward, anytime the American people want to know something that I or a former president wants to withhold, we will have to consult with the Attorney General and the White House counsel, whose business it is to ensure compliance with the rule of law. Information will not be withheld just because I say so. It will be withheld because a separate authority believes my request is well grounded in the Constitution. Let me say it as simply as I can. Transparency and the rule of law will be the touchstones of this presidency.
Now, those are very strong words, and I completely agree with President Obama's statements. However, during last week's Sunshine in Government Week, many transparency groups expressed concern with this administration's compliance with FOIA. These concerns address a variety of issues, including agency stonewalling, delays, and excessive fees. Recently, the Central Intelligence Agency had a class action lawsuit filed against it for illegally discouraging requests by imposing significant fees without notifying requesters. The Department of Homeland Security has also been accused of charging exorbitant fees on FOIA requests. During this committee's review of agency FOIA logs, we found one case where the agency charged the requester over $70,000. The Department of Justice, which is responsible for setting agency FOIA compliance, has also been accused of defending federal agencies when they choose to withhold documents. Last year, when asked by the Supreme Court about President Obama's presumption of openness, a Department of Justice lawyer said, We do not embrace that principle. Clearly, there is more work to be done to ensure that citizens get prompt, substantive responses to their requests for government information. Technology is a valuable tool for promoting transparency and is the focus of our hearing today. I look forward to hearing from our witnesses about ways to make government more transparent and more accountable to the public. I now recognize the distinguished ranking member, Mr. Connolly, for his opening statement.
I thank the distinguished chairman. As I said before, my great-grandfather Kelly would be proud that there was a Kelly sitting in that chair. He'd be even prouder if there was his great-grandson sitting in that chair, but that's a different issue. We're delighted to have you all here today, and I agree with the distinguished chairman's the first part of everything he said, and I disagree with the second part of everything he said. I actually believe there's a record of enormous transparency that's unprecedented in the Obama administration. I actually believe this committee, despite its best efforts, has actually allowed that to be documented. Last year, for example, the full committee held a hearing on FOIA, and hyperbole and rhetoric aside, we discussed several FOIA advancements since 2009. First, the President issued the executive order the distinguished chairman referred to, directing agencies to err on the side of disclosure rather than secrecy, a reversal, I might add, of the Bush-era policy, which certainly favored secrecy, led by the distinguished Vice President at the time, Dick Cheney. Second, agencies reduced the FOIA backlog, this is a fact, by 40%, eliminating 55,000 backlog FOIA requests, an accomplishment by any measure. At the time, President Obama had only been in office 2 years. Last year, the number of FOIA requests increased dramatically, and yet 23 of 37 agencies, more than half, still managed to reduce their backlog. Unfortunately, over 250,000 new requests submitted to the Department of Defense and the Department of Homeland Security increased the government-wide FOIA backlog. While most agencies improved FOIA management substantially, it seems some could still learn from the best practices of others. To that end, I appreciate the EPA witness appearing at today's hearing to discuss its FOIA module web portal. The EPA's portal, which works for multiple agencies, helps the public submit and track FOIA requests, search for information, and view agency responses to FOIA requests. It allows agency employees to log in securely and process applications. For relatively modest upfront and annual operating costs, this portal allows EPA to save approximately $3.5 million over a 5-year period. The sufficient return on investment should encourage other agencies to consider adopting similar modules to achieve similar savings and efficiencies. Similarly, agencies are unlikely to be able to reduce FOIA backlogs or provide quality FOIA responses, a metric that is every bit as important as speed of responding, if agencies are subjected to arbitrary reductions in the size of their workforce. We can't have it both ways up here, Mr. Chairman. We can't complain about the responsiveness on FOIA requests while we're hacking away at the federal workforce and disparaging federal employees in the process. We can't allow antipathy toward the federal government to impair our ability to respond to citizens' needs. The Office of Personnel Management projects that retirements will increase some 18% next year alone. In addition to understanding potential technological improvements for FOIA, we need to recognize staffing needs as well. I want to thank the witnesses for appearing today, and I look forward to learning especially more about EPA's module to see how we can save money and perhaps help other agencies. Thank you, Mr. Chairman, for holding this hearing.
I thank my Irish colleague. I can't do what my grandfather would have wished, but I'm sure he's glad.
Great-grandfather.
Your great-grandfather, well, Kelly. Well, there's more Kellys and Connollys there that we can possibly keep track of. We are going to recognize right now our first panel. First, Ms. Melanie Ann Puste she is the Director of Office of Information Policy at the U.S. Department of Justice. Thank you for being here. Ms. Miriam Nesbitt is the Director of the Office of Government Information Service at the National Archives and Record Administration. Ms. Nesbitt, thank you for being here. And Mr. Andrew Batten is the Director of Information Collection in the Office of Environmental Information at the Environmental Protection Agency. Mr. Batten, thank you for being here. Pursuant to rules, committee rules, all witnesses will be sworn in before they testify. Would you please stand and be sworn in? And raise your right hands. Do you solemnly swear or affirm that the testimony you are about to give this committee will be the truth, the whole truth, and nothing but the truth? And let the record show that everybody answered in the affirmative. Thank you, and please be seated. Now, in order to allow time for discussion, if you could, please limit your testimony to 5 minutes. We won't be real strict on that, but if you could, that would be great. Your entire written statement will be made part of the record. Now, I now recognize myself for 5 minutes. Oh, I'm sorry. Oh, I'm sorry. Ms. Postay, I'm sorry. Would you please open?
Certainly. Good afternoon, Chairman Kelly, Ranking Member Connolly, members of the subcommittee. I'm pleased to be here today to discuss agencies' use of technology in administering the Freedom of Information Act and the Department of Justice's continuing efforts to ensure that President Obama's memo on the FOIA, as well as Attorney General Holder's FOIA guidelines, are fully implemented. The Attorney General issued his new FOIA guidelines during Sunshine Week 3 years ago, and based on our review of Chief FOIA Officer reports and agency annual FOIA reports, it's clear that agencies are continuing to make significant, tangible progress in implementing the guidelines and in expanding their use of technology to do so. In fiscal year 2011, despite being faced with a noticeable increase in the number of incoming requests, agencies were able to process over 30,000 more requests than the previous year. The government released records in response to 93% of requests where records were located and processed for disclosure, marking the 3rd straight year in which such a high release rate was achieved. The government also improved its average processing time for simple requests. Agencies continue to meet the demand for public information by proactively posting information on their websites. Many agencies have also taken steps to make those websites more useful by redesigning them, by adding enhanced search capabilities, and by utilizing online portals and dashboards that facilitate access to information. For example, the Department of Energy created a full-text searchable FOIA portal that provides access to documents previously released under the FOIA. Similarly, numerous components of the Department of Defense made improvements to their websites and created systems for the proactive postings of contracts. I'm particularly proud to report on the successes achieved by the Department of Justice. For the 2nd straight year, DOJ maintained a record-high 94.5% release rate for those requests where records were processed for disclosure. Perhaps even more significant, when the Department released records, it did so in full in response to 79% of requests. Despite 3 straight years of receiving over 60,000 requests, the Department also increased the number of requests processed, and we reduced our backlog by 26%. My office carries out the Department's statutory responsibilities to encourage compliance with the FOIA. And as part of our work in implementing the Attorney General's guidelines and our commitment to the initiatives in the National Action Plan for the Open Government Partnership, OIP is leading the effort to maximize the use of technology across Federal agencies to streamline the FOIA process and to improve the online availability of information. Just this past year, OIP reconvened the Interagency FOIA Technology Working Group to exchange ideas on this important topic. The group discussed various tools to assist with FOIA processing, including technology that can aid in the search and review of documents, shared platforms that allow for simultaneous review and comment on documents, and software that automatically identifies duplicative material. An area that I believe holds great promise in increasing the efficiency of agencies' FOIA processes is the use of litigation software in the FOIA context. Agencies often have to manually review hundreds, if not thousands, of pages of paper and electronic records for both responsiveness and duplication before disclosure analysis can even be made. By utilizing e-discovery tools to perform some of these necessary administrative tasks, agency FOIA staff can focus their efforts on reviewing records for disclosure and providing a timely response. OIP has already begun using this technology, and we will continue to develop its capabilities with the goal of helping all agencies employ similar tools for the overall benefit of FOIA administration. We are also researching new technologies that will substantially improve the FOIA consultation process by allowing multiple components and agencies to review and comment on material simultaneously. With well over 1 million visitors since we launched last March, the Department's new government-wide FOIA website, FOIA.gov, has revolutionized the way FOIA data is made available to the public and has become a valuable resource for both requesters and agencies. The website graphically displays the detailed statistics contained in annual FOIA reports and allows users to compare data between agencies and over time. The website also serves as an educational resource by providing useful information about how the FOIA works, where to make requests, and what to expect through the FOIA process. Recently, we expanded the function of the site even further by adding a new search tool that will help the public locate information that's already available on federal government websites. This new tool allows the public to enter a search term on any topic of interest. FOIA.gov will then search across all government websites at once, and then it will capture documents posted anywhere on an agency website. We launched yet another new feature just a few weeks ago by including hyperlinks to the online request forms that agencies have to make it easier than ever to make a FOIA request. In an effort to improve FOIA processes and increase efficiency, there are over 100 offices across the government that have already developed the capability to receive requests online. I'm very pleased to report that OIP itself, my office, has just launched an online capability, and requesters can now make requests and file administrative appeals online. Our portal also allows the public to establish their own user account, and they can track the status of their request or appeal at any time and receive their determination from OIP through the portal. Looking ahead, we'll continue to work on the administration of the FOIA and to enhance government transparency, and we'll be looking to explore new ways to utilize technology to achieve these goals. We look forward to working with the committee on these important matters. Thank you.
Thank you very much, Ms. Mustay. Ms. Nesbitt.
Good afternoon, Chairman Kelly, Representative Connolly. Thank you for the opportunity to appear before you to discuss the Freedom of Information Act and information technology. I heard from your opening remarks that you both have a sense of some of the challenges that face the government, the 15 cabinet-level departments and the 84 agencies that administer the FOIA. We certainly have seen that. As you know, the Open Government Act of 2007, which amended the FOIA, created our office to do several things: to review agency policies, procedures, and compliance with the law, to recommend policy changes to Congress and the President to improve the administration of FOIA, and also to resolve disputes between FOIA requesters and the federal agencies. We opened our doors 2.5 years ago in September 2009. Our work has reached customers in 48 states, the District of Columbia, and 13 foreign countries. Individuals, including veterans, researchers, professors, journalists, attorneys, and inmates, comprise more than 3/4 of our workload. Our cases in fiscal year 2011 involved 42 federal agencies, including all 15 cabinet-level departments. In carrying out our mission, therefore, we do see how agencies are using technology every day to administer FOIA, tracking requests, searching for and reviewing records, posting frequently requested records online, and using agency websites to provide information about FOIA resources. In 1996, Congress passed the Electronic Freedom of Information Act amendments, or the eFOIA, to clarify that the law applies to electronic records as well as traditional paper records. 16 years later, agencies are still working to fully implement the eFOIA. Agencies continue to improve and modernize their processes, but improvements can still be made, as you both have noticed. Some obstacles that we have noticed are outdated technology and challenges posed by the need to properly manage electronic records. Certainly, my parent agency, the National Archives and Records Administration, takes those needs and concerns to heart and works on those every day. Mr. Batten from the Environmental Protection Agency is going to give you details of the FOIA model, a one-stop shop portal for FOIA requests. My agency is a partner in that project with EPA and the Department of Commerce because we believe it has great potential to improve the public's access to government information and to save the taxpayers money by sharing agency resources and adapting existing technology. Other departments and agencies have expressed interest in the partnership, and we hope they will join us. The FOIA module is scheduled to be launched for agencies this summer and unveiled to the public in October. An area in which FOIA and technology intersect is with proactive disclosure of government records. The eFOIA amendments require every agency's website to include certain information made public under FOIA. Agencies are continuing to make additional information available on their websites in rather staggering amounts. In order to ease the public's navigation across agencies' websites, we are encouraging them to standardize FOIA sites to ensure a customer-friendly and efficient way for the public to find FOIA resources. Last week, in observance of Sunshine Week, the national initiative to promote open government, OGIS posted on its blog some suggestions to improve the FOIA process administratively, such as top-down support for FOIA, developing with stakeholder input, an easy-to-use template for agencies to customize, standardizing it and indexing online FOIA reading rooms, and providing full contact information for designated FOIA professionals. Finally, OGIS has observed that collaboration across agencies is a cost-effective and beneficial tool for exploring ways to improve the administration of FOIA through existing technology. There are several efforts underway in the federal FOIA community to look for ways to collect the information technology requirements of FOIA professionals and communicate those to companies that create products for them to use, to identify technologies that agencies now use that can be repurposed for FOIA, and to share knowledge about FOIA issues such as complex database requests and best practices to help agencies handle them better. We appreciate the subcommittee's efforts to examine ways that FOIA can work better and more efficiently for everybody, the public and the agencies. And we thank you for the opportunity to testify.
Thank you, Ms. Nesbitt. Mr. Batten.
Good afternoon, Chairman Kelly, Representative Conley, and members of the subcommittee. My name is Andrew Batten, and I am the Director of the Office of Information Collection in the U.S. Environmental Protection Agency's Office of Environmental Information. I am pleased to appear before you today to discuss the FOIA module developed in partnership with the Department of Commerce and the National Archives and Records Administration. I am also pleased to join my colleagues from NARA and DOJ on this panel. EPA is committed to the implementation of the Administration's open government and transparency goals. EPA demonstrated this commitment by striving for a reduction in processing time of FOIA requests and recognizing that information technology creates an opportunity to improve our FOIA performance. EPA has sought continually to be proactive in improving our FOIA administration and to be innovative in the use of technology to enhance our FOIA performance, both internally and for the public. We made it a priority to deploy a system to help track requests and produce EPA's annual FOIA report. Further, the agency believes that efforts made to improve processing and extend public access to FOIA responsive documents are very much in keeping with the principles of the Administration's Open Government Directive. Embracing the Directive's mandate for greater transparency, EPA has posted databases from multiple program areas to its website containing information frequently requested under FOIA. To build on our strong record of transparency, innovative use of available technologies, and overall FOIA performance, in June of 2010, our Deputy Administrator, Bob Perciasepi, launched a cross-EPA work group to identify ways to improve further still the efficiency and consistency of our FOIA processes, to explore the use of tools to inform citizens, as well as update regulations and policies. The work group report included a recommendation to invest in tools and technologies that streamline FOIA operations and increase public access and transparency. As managing partner of Regulations.gov, we explored whether their e-rulemaking program's technology infrastructure could be used to accept FOIA requests. We procured a third-party technical and cost feasibility assessment that concluded that the e-rulemaking program's technology infrastructure could be used to accept FOIA requests, store them in a repository for processing by agency staff, and allow responsive documents to be uploaded into the system and posted for public access. These analyses indicated that leveraging the e-rulemaking technology infrastructure could be accomplished with a fairly modest investment. EPA shared the analyses with the Federal Government's two FOIA leads, the Department of Justice and the National Archives Administration, to validate the approach of developing a FOIA module. The module would automate FOIA processing and reporting, store FOIA requests and responses in an electronic records repository, and enable the public to search, access, and download previously released FOIA responses for participating agencies. The module would also accumulate statistics on FOIA actions throughout the year and summarize this information for an agency's annual FOIA report. Later, other agencies were invited to learn about and explore the use of a possible FOIA module. Through this broader outreach, requirements were developed and refined for how such a FOIA module could operate. We continued our conversations with our Federal partners based on the assessment, and a number of agencies expressed interest in the FOIA module. Following the finalization of the workgroup's recommendation for a FOIA module, EPA entered into a partnership with NARA and the Department of Commerce. These agencies provided funding to help design and develop such a solution. The construction and deployment of this system is estimated to cost $1.3 million. The module is scheduled for partner agencies to use later this summer and available for public submissions by October of 2012. As development of the FOIA module recently reached a sufficient state of definition to clarify how its component capabilities are expected to work, managers in both EPA and DOJ recognize that it has become timely to harmonize EPA's efforts on the FOIA module with the functions provided by DOJ's FOIA.gov, now and in the future. Accordingly, we have begun a series of conversations about each organization's electronic tools to understand in greater detail any near-term technical coordination needs and to identify potential future complementary capabilities. We look forward to continuing productive interagency collaboration moving forward on this important work. I appreciate the opportunity to provide this testimony and will be happy to respond to any questions you have.
Thank you. Thank you all three for being here. Your complete written testimony will be in the permanent records. But thank you. You're all within the 5 minutes. It's very good. It usually doesn't happen here. I'm going to recognize myself for the first questions. Ms. Mustay, DOJ says it's going to develop its own portal. Why doesn't it just choose to work with the EPA on theirs?
We actually just launched our portal, so we're done, and with the portal that we have. And actually, as I mentioned in my testimony, there are 100 agencies that have online request portals. So this has been a wave of use of technology across the government. As I mentioned, one of the focuses of the Attorney General's FOIA guidelines was to encourage agencies to utilize technology. So we've had a whole range of options being explored across the government, and we're now, as I said, up to over 100 agencies with online request portals. What FOIA.gov does, which is yet another feature, one of again, as I mentioned, as a new feature for FOIA.gov, what we're doing is including on that website links, hyperlinks to all the online request forms that are available across the government to make it easy to reach them through FOIA.gov.
Okay. Listen, DOJ is responsible for setting FOIA policy and compliance across the government, as well as litigating on behalf of all FOIA lawsuits. Has there ever been a case where the Department of Justice has disagreed with an agency's withholding of information and refused to defend it?
There have definitely been cases where additional information was released as a result of application of the Attorney General's guidelines. We saw that obviously most especially in the immediate wake of issuance of the guidelines. And then of course, that's been 3 years ago now, and so we have been working very hard to train agencies and implement and focus on the new requirements, to apply a foreseeable harm standard, to not withhold information just because you legally can, some of the things that we saw the President mentioning in the video that you showed a moment ago. So at this point, we have a really a nice ingrained understanding of the provisions of the Attorney General's guidelines across the government.
Well, last year, a DOJ lawyer told the Supreme Court that DOJ does not embrace the principle of openness. Can you explain the disconnect between what the President's memo was and the DOJ's action?
No, I'm happy that you asked me that so I could clear that up. As I understand the exchange that occurred during the course of the Supreme Court argument was simply not that there was a disagreement with the presumption of openness. The actual question being asked of the attorney was whether FOIA exemptions should be interpreted narrowly. And of course they should be. We have Supreme Court precedent that says FOIA exemptions should be interpreted narrowly. But there's a corollary principle, and that's that FOIA exemptions must also be given meaningful reach and application, because that's consistent with the fact that Congress included in the FOIA exemptions for a purpose, to protect vital interests like personal privacy, national security. So what he was attempting to do was to explain that the concept of narrow interpretation of exemptions had to be analyzed in reference to the corollary principle that exemptions must also be given meaningful reach.
Thanks. Listen, the purpose of the hearing is to examine ways to use technology to improve transparency. What do you think are the most important advances in this area, and what are the biggest challenges? I mean, so each of you have very unique perspectives on this, so if you could. You know, Mr. Batten, why don't you start, and we'll give Ms. Postet a chance to catch her breath.
I certainly think the biggest challenge that we face, and one of the main reasons we went into development of the module, was to improve our efficiencies in being able to meet the public demand. Through the use of the module, we're really internally focusing on improving the process to answer FOIAs, bring consistency into the process, and create a repository for future use. For the public, we're increasing transparency, allowing them to submit online, track their progress throughout, and have access in the end. And all these are challenges that we face through some of our antiquated approaches.
Okay. Ms. Nesbitt.
Representative Kelly, I think that the partnership that you've heard about and the effort to build a one-stop shop portal really gives you an indication of where a lot of people think that the future of technology is going to take us, with having something that is really easy for the public so that they don't have to go to 350 places to make a request, to be able to quickly see what information has been already disclosed and is publicly available, so maybe they don't even have to make a request. And also, on the other side, making it easier for agencies to share the resources they have and also to process requests in a more efficient way. We have many, many different systems out there, and trying to find out ways that we can actually share with each other what we already have instead of coming up with so many different solutions, I think just has some natural cost avoidance built in.
Thank you. Ms. Postet.
I'll mention something that we haven't talked about yet so far this afternoon. One thing that's important is, as agencies have been working very diligently to proactively post information, to anticipate interests in records and put those records, and sometimes more than records, put databases, put whole websites up dedicated to particular topics. They're really working to try to anticipate interests in records and get information out to the public before a request is even made. So there's lots of releases being made by agencies separate and apart from FOIA, and that's great because that's part of the Attorney General's guidelines as well. But one thing that we think is important is to have the ability to capture all that information. So that was one of the reasons why we put on FOIA.gov the Find tab, so that if you are a researcher or you're a student and you're looking for information on a particular topic, there's a way to look across agency websites and capture them. But going the next level, what we're working on now at the Department is metadata tagging, which is to implement, our plan is to work with GSA to actually have standardized ways to tag records before they're posted, to make the search process for them even that much more precise. We have to be careful as agencies are very enthusiastically putting information up on the web. Websites can easily become overwhelmed with data. So it's very important that there be a way to find the information that you're looking for.
Thank you. And now we'll recognize the ranking member, Conley.
Thank you, Mr. Chairman, and welcome to our panelists. You know, I spent 14 years in local government before coming here, and in the Commonwealth of Virginia, we actually have some of the most stringent FOIA laws in the United States. Now, by the way, the FOIA laws did not apply to the state legislature, of course. But my schedule was subject to FOIA. My phone logs were subject to FOIA. My emails were subject to FOIA. I had to deal with FOIA requests personally, and as chairman of the county on behalf of the county government. And sometimes they would be overly broad requests that weren't very specific, and it was very hard to respond to them without producing reams of material that presumably the requestor didn't really intend. A lot of times, if the FOIA came from the press, they were overly broad to try to make sure they didn't draw it so narrowly that we only juridically answered the exact question they made. So they tried to often make them overly broad, and we'd have to negotiate with them to say, well, you need to be more specific, otherwise you're going to get, the Encyclopedia Britannica printed. And so I've seen the challenges of FOIA. All good attorneys, and certainly our county attorney, always advised agencies and individuals in the local government, whatever you do, do not stall, do not, stonewall, don't try to create barriers to responding in a timely fashion, or you can find yourself prosecuted. You can find yourself in violation of the law. So with that introduction, Ms. Puste, maybe I could start with you. Presumably there is also similar guidance given to federal agencies in terms of, by and large, you have to presume it's a legitimate request and be responsive. Would that be fair?
Oh, absolutely, absolutely. There's a whole range of things that agencies do routinely, and certainly as part of our outreach and training to agencies. My office conducts trainings throughout the year. Every year we reach thousands of agency employees. And one of the there's many different techniques actually to use when working with requesters. A big advantage of open communication with requesters about what it is they're looking for is that if the requester can be more precise, the information can be provided to them more promptly.
Right.
And so requesters understand that and are always very happy to work with agencies, maybe not always very happy, usually very happy to work with agencies to help focus their requests.
Right.
But also there's a real push right now across the government to increase efficiency. Again, part of the AG's guidelines was specifically directed toward looking for more efficient ways to respond to requests. And we're seeing that agencies are processing more requests. They certainly processed 30,000 more last year, releasing more information. Mm-hmm. So there's a bigger picture here where agencies overall are looking to be cooperative to implement the guidelines
well,
as fully as they can.
If I could ask, and maybe Ms. Nesbitt wants to chime in here too, the Chairman alluded to some barriers, some problems still going on. The cost of providing material, sometimes seemingly exorbitant, and delays. So those are two metrics. I wonder, are we measuring that we're bringing down the response time so that we are more responsive? Are we also measuring the other impediments that the Chairman rightfully cited, such as the cost of providing the material requested, so that we're not creating barriers for people needlessly?
I think that's been trying to deal with those kinds of early speed bumps, in fact, is something that I know my office has worked very hard on. As you know, we're part of our mission is resolving disputes between FOIA requesters and the agency. So we deal with those every day, and in fact, fees and delays continue to be some of our largest numbers of our cases. There's still problems. But there is also, we see a corresponding emphasis on customer service, on picking up that phone as quickly as you can and talking to the requester, to be able to talk about the scope of the request so that you don't have lots of time spent looking for something that the requester is not even interested in.
Right.
Those are very, very fundamental customer service things that we are certainly seeing people trying to do a better job of.
Mr. Chairman, I see my time is up. How does the Chair wish to proceed? I do have a few more questions.
Let's do another round.
Fine.
Yeah, okay.
I yield to the Chair.
Thank you. You know, the Open Government Act changed fee waivers and statuses, and I know there is some confusion out there, and I really, when we played the President's opening remarks, maybe he created a Pandora's box he didn't mean to. When we start telling people about openness and transparency and, you know, everybody to have access to almost everything and anything that you want anytime you want it, and I understand, I'm not a lifetime politician. In fact, I've only been here a year, so I understand you can say things that sometimes sound good in front of a group, and then you turn back to the agencies that handle them, and they say, my gosh, I wish I hadn't said that. It creates an awful lot of problems for us. But there's a lot of lawsuits, is there not? I mean, there's some suits, and why do we have so much trouble with the excessive fees? Ms. Nesbitt, maybe you can weigh in on that. I know the ranking member had asked something about that, but there is some concern out there.
Representative Kelly, there's a lot of confusion, even both amongst requesters and agencies, about how the fee categories work and the fee waivers. So I think actually this is one of the first things that a FOIA Public Liaison Office, a FOIA Customer Service Center can do, is to work with the requesters to explain them. Certainly, as I mentioned, my office has a number of cases that revolve around fees, and we find ourselves that can definitely be a barrier, but if you walk through what the requirements are, both for what fee category you're in as well as the fee waivers, it can really help. I'll give you an example. Last year we had a requester come to us concerned because it had gotten a bill for $450,000 to process a big database request. And we were able, working with the agency, which was very cooperative, and the requester who was seeking to avoid a lawsuit, to resolve those issues pretty quickly and get to the substance of the case.
You know, I want to get back, Ms. Musty. In your opening statement, you said 93.1% of requests were handled. Now, there's some confusion on that. I'm just looking at something that while we claim, the White House claims that there were 93% of the time, they didn't include cases where there were no responsive records, cases where the request was considered by the agency to be improper, or cases where a requester did not pay fees for records. When all those cases are included, the response rate drops down to only 65% of those, 65% rate, and then a lot of those are heavily redacted. So when we talk about response rate, because I think one of the things I've noticed since I've been here, the American public oftentimes feels they're being gamed. They're being told one thing, and the actual figures seem to go in a different direction. So maybe you could clear that up for us. Sure.
No, I'm happy to, and I'm glad you asked that question. And we refer to it as a release rate, actually. But first, just in terms of the overall numbers, and to address your last point, all the detailed statistics about the numbers of requests that are handled by an agency, the disposition of the request, the time to get to your comment about how much time it takes, all of that is incredible detailed information. Is all required to be prepared every year by every single agency. It's part of their annual FOIA report. So all this information is publicly available. We then take all that information and have it on FOIA.gov now, where it's very easily manipulated and compared and contrasted. So in terms of accountability and transparency about how agencies are doing, the annual FOIA reports and FOIA.gov's graphic representation of that data is what should give you confidence that you're seeing the statistics however you want them. But to get to your question about a release rate and how we calculate it, the reason we calculate it by not every single request that's processed. We calculate a release rate based on those requests where there are records to be processed, because it's only for those requests that the agency has the decision to make, do I release or do I withhold? And out of those requests, where there are records where an agency is actually looking at the record and deciding, do I release or withhold, in 93% of those requests, information is released either in full or in part.
Okay, so I still, so the 65% that we talk about is an actual rate, is that more accurate than the 93%? Or are you saying, given the
Right.
instances you just talked about, that's how we're?
Right. The release, it doesn't, respectfully, it doesn't make sense to calculate a release rate based on the requests where there were no records, for example. When there are no records, the agency never has a chance to say, I want to release or I'm going to withhold, because there physically are no records in response to that request. So to have the release rate be meaningful, it is based on those requests where there are records.
So when we respond to people, we're setting the parameters, saying this is what we could do based on what we did have and what we can release.
Exactly.
Okay.
Exactly.
All right. So there is a clarification on that. And that's why that's how you're coming up with the 93%, and you're saying that's what we're staking.
We say the release rate is based on looking at the numbers of requests where records were processed for disclosure.
Okay.
And that's the reason why I say process for disclosure.
Okay. So that's the key, process for disclosure.
Exactly.
Okay.
Exactly.
Not on number of requests.
Exactly.
Okay. Very good. Thank you.
Sure.
Mr. Connolly.
Thank you, Mr. Chairman. Ms. Puste, picking up on something the Chairman was referring to, why would we ever redact something in a FOIA response?
Well, of course, there's 9 exemptions that Congress put into the statute to provide protection for a range of information. Personal privacy is the most frequently used reason to protect information.
Right.
I think
so,
all of us can agree on the
So,
need
first of
for
all,
that.
Congress provided for that.
That's right.
Secondly, that requires someone to actually go over the documents to make sure that we're appropriately redacting pursuant to these 9 exemptions.
Exactly. Exactly.
So that takes a little time, which could add to the backlog, not because anyone's trying to prevent information from getting into public hands, but because actually we're trying to protect the innocent and sensitive material. Okay. Now, let me ask a different question, maybe of you, Ms. Nesbitt, because your office is sort of the ombudsman for the Federal Government. Surely there's a difference between a FOIA request to EPA, for example. I want to see the studies on lead in water. I want to see the empirical evidence that led you to decide to regulate that issue. No national secrets there. Versus a FOIA request that says, I want to see the Department of Homeland Security's assessment of strategic assets and the plans to protect them and how many are vulnerable and how many are secure. I'd like to see that, please. Fair enough? There's a difference? And so that we have to manage those 2 different requests, even though they're both FOIA requests, with different levels of sensitivity and awareness and scrutiny. Would that be fair?
That's correct, sir.
So just using those 2 examples, maybe help walk us through a little bit in terms of time, resources, backlog, responsiveness, protecting national assets. I mean, maybe I'm a terrorist making that FOIA request using the Freedom of Information Act right? Because I want to save myself research time. I want you to do it. How do we protect ourselves, and how do we differentiate in these requests as a Federal Government between the one and the other?
Well, that's why you have very dedicated FOIA professionals who work on these kinds of issues every day. The processing of requests, as you point out, can be fairly simple, particularly when there is an easy search in one place and the response is, we don't have any records, to agencies, departments that are quite decentralized, and a search would require, for example, with the State Department, not only looking in Washington, but looking overseas as well, and checking for whether or not they're responsive records. Gathering those records, determining whether they're really responsive, reviewing them, and particularly if they deal with classified information or with sensitive information, whether it's financial, whether it's personal privacy, whatever the nature of the records, or maybe all of those in one document, reviewing them carefully to be sure that a release to one is a release to all, and that a release to one person who might be a very legitimate researcher is not going to also be turned into something harmful by a requester who doesn't have a beneficial idea.
And so in other words, we have to sometimes exercise some prudent judgment.
Every day.
And when we do that, it's always, in a sense, an arbitrary line. We're drawing a line saying, no, we're not going to go on that other side. And anyone, I say, it's a matter of opinion whether that's the appropriate line or it should be moved out here or whether there should be any at all. But nonetheless, the people making that judgment have to make that judgment.
And they have to make a decision so that the requester can know, what are you going to get? Are you going to get anything? How many pages?
Right.
Or are you not going to get anything at all? So that they get an answer.
Right. And a lot of our economic competitors in the world don't have FOIA. You can't go to Beijing and FOIA their plans for X, Y, and Z, or Tehran, or lots of other places. Mr. Chairman, would you indulge me just to ask Mr. Batten if he could just take a little bit of time to walk us through how their portal works and why so many people see it as perhaps a model for other federal agencies. And by the way, where are you from?
Thank you for that question. Both questions, Congressman. I'm from Pennsylvania. I grew up in Pennsylvania.
I know.
Spent a good deal of time there.
Fully rounded O's, though. All right.
Yep. In terms of how the module works, what the module is designed to do is, again, provide a single place for the 3 participating agencies to allow the public to come in and submit a request, track that request in a very open and transparent way so they know within the 20-day period that we're looking to respond that they know where in the process their request is. Also to give them an opportunity to have a dialogue if there are issues that need to be clarified with the FOIA staff and the requester. There's now a forum to do that. Next is providing access to the public to receive those answers so they can go to a particular spot, look at not only their request and the answers to that request, but other questions that may have been asked. So that is kind of the public side of this. On the inside, internal to the benefits to the agencies, a lot of what we, again, are stressing is processing efficiencies, the consistency in responses, having that repository for reuse so that we don't have to begin answering questions from the beginning again. Our current solutions don't have that repository that we can go back to and answer a question date forward. And that is a huge resource when it comes to a huge resource drain when we have to recreate the answers time and again. Also, providing referrals to other agencies as is necessary. Within the system, we have the ability to refer to our partnering agencies if there's a question, or maybe the FOIA should be directed to them. And again, providing that ability to enable a repository for searching for other agency purposes, such as electronic discovery. That's something Ms. Poustet mentioned in the beginning, that having that repository of electronically discovered information preassembled is very important.
Thank you. And Mr. Chairman, thank you for your indulgence.
Thank you, sir. It's nice working with you. It's easy. That is going to end the questioning for the first panel. We certainly do appreciate you being here today. And I think that we would both agree. I've only been with Mr. Connolly for a year, but the service that you provide our country is very great. And I know sometimes you have to prepare before a committee, and it seems like maybe we're at you for a certain reason. But we do represent the people of the United States, and we think it's very important that there's a clear and transparent approach to everything that we do in this government. So thank you so much for being here today. We appreciate your indulgence with us, and we're going to take a short recess, and we'll have a second panel.
I concur, Mr. Chairman, with your sentiments. Thank you.
Thank you. Okay, we're now going to welcome our second panel. Mr. Sean Moulton is the Director of Federal Information Policy at OMB Watch. Mr. Moulton, thank you for being here with us today. If you could, pursuant to committee rules, all witnesses are sworn in before they testify. Would you please stand and raise your right hand? Do you solemnly swear or affirm that the testimony you are about to give this committee will be the truth, the whole truth, and nothing but the truth? Thank you. Let's show that the witness answered in the affirmative. I know there's a lot of time for discussion. If you could, Mr. Moulton, stay within the 5 minutes, although as you seem, we're pretty liberal with that. I'm usually not liberal that way, but sometimes I am. But being beside Mr. Connolly, we're a little liberal today. So if you could, we're going to allow you your opening statement and somewhere within the 5-minute range, please.
Chairman Kelly, Ranking Member Connolly, members of the subcommittee, thank you for inviting me to testify today on the important topic of how technology can improve implementation of the Freedom of Information Act. My name is Sean Moulton. I'm the Director of Federal Information Policy at OMB Watch, an independent, nonpartisan organization that advocates for more open, accountable government. Improving citizen access to public information has been an important part of our work for 30 years. We also have experience using technology to make government information more available to the public online. I'll begin with a look at the current situation of FOIA implementation. Last week, OMB Watch published our assessment of FOIA performance at 25 agencies. Our assessment evaluated processing of FOIA requests, the rates of requests granted, and the use of exemptions. Across these issues, the news is mixed, with progress in some areas as well as a few setbacks. In 2011, the Obama administration increased its FOIA processing and processed the highest number of requests since 2005. Unfortunately, the number of requests received increased even faster, resulting in a rise in the overall backlog. Although many agencies have made progress on reducing their backlogs, continued improvement is still needed. In terms of granting requests, 2011 added to the Obama administration's 3-year average of a 95% granting request rate, whether in full or in part granting. This is higher than the Bush administration's average of 93%, or the last years of the Clinton administration at 89%. However, the Obama administration more often partially granted requests compared to the previous administrations. Finally, on exemptions, the total use of exemptions dropped by 7%. Notably, the use of the most discretionary exemptions declined as well in 2011. Use of Exemption 2, internal agency rules, decreased by 63%, and use of Exemption 5 for interagency memoranda fell by 14%. These declines come after steady growth in the use of both exemptions during the Bush administration. Turning now to the issue of technology, OMB Watch strongly believes that technology can improve FOIA performance. For several years, OMB Watch has advocated for the development of a robust electronic FOIA system that incorporates 3 main improvements: allowing the public to submit and track requests electronically at a centralized site, improve communication through the use of email, and to post online in a searchable system documents released through FOIA. Many of these needed reforms are embodied in the FOIA portal project being led by EPA. The project would provide a single interface for the public to submit requests to any participating agency and would modernize the infrastructure agencies use for processing, tracking requests, and publishing information. When completed, we believe the FOIA portal will help agencies process requests faster at a lower cost, while expanding online disclosures and improving requesters' experience. Mail delays and postage costs would be reduced through online communications. Portal would also speed up consultations and referrals between agencies. Released documents would be uploaded to a public website available both to the requester as well as to any other searchers. Withheld documents would remain in the system, restricted from public access, but quickly available to agency review in the event of an appeal. Although the project is at an early stage, we believe it merits support from Congress. Congress should make it clear that it expects every agency to participate in such a centralized e-FOIA system. Congress can also play a helpful oversight role to ensure that such a system maintains high standards of usability for the public. In addition to the FOIA portal, OMB Watch recommends other key technology reforms to improve FOIA. These suggested reforms include, first, update the electronic FOIA provisions to strengthen the standard for publishing released FOIA documents online. Second, expand the types of information agencies are required to proactively post on their websites. Third, establish a government-wide online document disclosure goal. And fourth and finally, update the E-Government Act to better address electronic records management and disclosure needs in IT procurement decisions. In conclusion, OMB Watch is fully committed to the Committee's goals of using modern technology to improve transparency. With the right reforms and investments, FOIA can be quicker, easier to use, and more proactive in disclosing information to the public. I sincerely thank you for the opportunity to address this committee, and I look forward to your questions.
Thank you. And again, everybody's right on time. They have 5 minutes. You made a comment in your opening remarks that when you were saying harshly that the administration answered it harshly, what does that mean?
Partial. Sorry if I didn't pronounce it. Partial disclosures where a requester would ask
partial.
for a lot of documents or even one document, and it might be redacted, or some of the documents disclosed but not all. An exemption is cited to withhold some of that information. So a partial instead of a full grant.
Okay, and as you mentioned, if I remember correctly, in the Clinton administration, it was an 89% request fill. Is that correct?
That's correct. That's both a combination of both partial and full grantings. The Obama administration uses a significantly higher partial granting as a percentage of that. There are about 50% of the grants they make or the requests they answer are partially granted rather than full granting.
Okay, so when we talk about the information being answered, now clear that for me, because I'm having a little. You're saying that 50% are partially answered.
Right, and then full granting would make up the remaining. I think it's 43%.
43%, yeah. Okay.
And then that combines to be a 95% average over the 3 years.
Okay, and then the Bush administration, it was a 93%.
93% combined, and their partial was. Trying to remember this.
No, that's okay. I mean,
but it was their use of partial.
You're not running for office. You're allowed to make mistakes when you're talking to us. We're not going to film that and play it back later on. So that's okay. But I really so we've had from the Clinton administration it was 89%, to the Bush administration 93%, and now under the Obama administration 95%. So we've seen a marginal increase of about 2%. Is there anything at all? I know in 2008 you had some ideas that you presented or submitted to then President-elect Obama. A lot of it been taken in and placed into effect?
I think the recommendations we made during the transition have had some impact. As Ms. Puste testified, there have been a number of agencies that have been using technology more aggressively and opening up their online forms for requesting information. They call them portals. The problem really is lack of consistency. Not all the agencies are creating the same types of capacity online, and some of them aren't. And what we think the FOIA portal that EPA is developing really offers is a level of consistency across government that is greatly needed.
Okay. So the EPA, and Mr. Batten was talking about this portal that they're opening now, the DOJ, is it going to be similar to the EPA's? Or it sounds to me like the EPA has really done a good job with this portal as they're coming forward. And I think, Miriam, you were talking about more of a partnership or a sharing. What do you see coming with that? Is it looking like it's going to merge, or they're going to have something that's very similar and is easy?
Well, certainly it's hard to say what will come about. I would say that the features that we know that are being developed for the EPA FOIA portal far outstrip other portals and other efforts that we've seen from other agencies. It really is trying to put all of the modern advances and improvements that have been developed for FOIA in one place. The FOIA portal that Ms. Puste was talking about really was a portal to allow you to request information online. but I don't believe it has the same level of the ability to well, it does have tracking, but then to post the information to allow electronic communication.
Okay. Mr. Moulton, thank you. I'm going to now yield to Mr. Conley.
Thank you, Mr. Chairman. And just to clarify, in your response to the Chairman's last question, you're referring to the DOJ portal versus the EPA portal.
Correct.
Yeah.
The DOJ portal is right now mostly just a request information online. The EPA portal is going to be much more robust.
Right. And so, Mr. Chairman, I think you were on to something there that would suggest the EPA portal really still could be a model even for DOJ.
Absolutely.
Yeah.
Yes.
All right. Yeah, exactly. Thank you. Again, in response to one of the Chairman's questions, I think, correct me if I'm wrong, the statistic was something like 93% in the Bush administration, 95% in the Obama administration.
That's the average rate of disclosure, yes.
Right. But what has to be taken into account in response to the Chairman's query is the difference in volume. I mean, 93% of, half a million is one thing. 95% of a million is quite something else again. So wouldn't we have to take into account the volume difference too, not just that percentage? It's more than a marginal increase if you take into account volume.
Compared to the last years of the Bush administration, the volume is significantly higher.
Yeah.
The Bush administration did handle, at the beginning years when they took over from the Clinton administration, had a higher volume that they dealt with for several years, and requests steadily came down.
Right. I'm just saying the percentage may be a little misleading depending on the volume we're talking about. That's all. I want to ask you 3 questions, and I'm going to try to get them in my 3 minutes and 29 seconds. So, thank you, Mr. Chairman. Uniform criteria, and I think that's a really good point you were making there. If we have 70-something agencies or 100 different agencies and they all have different criteria, now sometimes perforce they may have to, given the nature of the specialized mission. But we ought to have some sort of universal criteria so that we're all operating from the same playbook. Are we making some headway in that regard, do you think? Is Ms. Nesbitt's ombudsman role, her agency's ombudsman role, helping us in that respect?
I think we are making progress. We've seen a lot of agencies invest in technology, improve their processing, improve their proactive disclosure. It's partly comfort level, comfort with technology, comfort with FOIA, that leads some of the agencies to advance further. And other agencies, sometimes it's also a resource question of having the resources to make those investments and to make those improvements.
Okay. Again, we were talking about partial responses, and that can be either, I suppose, depending on one's point of view, a good thing or a bad thing. A good thing in that, well, at least you're trying to be responsive, but you can't be 100% responsible for the exemptions or privacy or whatever it may be. On the other hand, partial may be, no, you're not being responsive. You're actually kind of covering up and impeding transparency. So what's your take on this increase in partial responsiveness by this administration?
It is difficult to decide exactly what's going on just based on the statistics. The increased use of partial disclosures as part of the response from government has been growing for many years, since about the year 2000. It's been growing steadily, more partial disclosures, fewer percentage-wise full disclosures. This could be a change in government information. It may be that government information is becoming more commingled with privacy information or national security information, and so partial redactions are a necessity. It could also be a change in requests. That people are requesting larger amounts of information and that some of it is something that has to be withheld. Or it could be, as you say, a bad thing. It could be a change in the attitude and the implementation by the agency. From the statistics, it's impossible to tell. It would really require an audit of requests, a random audit to see what was requested, what were responsive, and what was given to figure out exactly what's going on here and driving this.
Right. And that's a good point. I mean, for example, maybe there was a 1,000% increase in the Homeland Security request we went over hypothetically, and of course that's going to be a partial response if you're lucky. Whereas, lead and water, I'm willing to, all right. My final question real quickly, do you see a pattern of more or less arbitrary barriers, obstruction, needless delays in the last few years, or are we improving in that regard?
And you mean in processing FOIA requests?
Yes, I'm sorry. Yeah.
I think again that the answer is that the record is mixed. I think some agencies have made a lot of improvements in removing pre-existing barriers, and I think that's something to also stress is that some of these barriers have been embedded in the process for years, predating this administration or the previous administration. And
it's a culture.
A culture.
Yeah.
A culture of if it can be withheld, then it's better to play it safe than sorry. And that is something that's very hard to overcome. There's a lot of training that's going on. There's a lot of, as I said, investment at various agencies going on. And I think some agencies have made greater strides than others. And we have seen some agencies who have kept a more business-as-usual attitude towards processing FOIA requests and having the same types of responses. Even when they can disclose more information, they choose not to.
Thank you. Thank you, Mr. Chairman.
Thank you.
Thank you, Mr. Connolly. I would say that wherever we talk about with all this information that's out there, first of all, people are a lot more comfortable now. They're becoming more comfortable with technology, and they're getting on and they're doing a lot of things that maybe they wouldn't have done in previous administrations. But also, the world's changed dramatically after 9/11, and I think, again, what we put out there, I don't know of another country in the world that allows more people to look at what it's doing. And I would say that our model is probably the most perfect model out there, but it also does allow. It does allow for an openness that no place else in the world does allow. I think we do have to be very careful with it. But I would agree with Mr. Connolly. I think that, the world changing so quickly, the amount of information that's out there, we do have to be very careful with it. The President's opening remarks, again, I go back to, sometimes we have to be careful. We open a Pandora's box. We establish a standard that may be hard to live up to in the real world. And as we go forward, I think that the public does expect, and I think they're maybe more suspect of things than they were before. So we have a lot more people asking a lot more questions at a lot different levels that, while some people think that's very healthy, and I do think it's healthy, but again, there's a lot of responsibility with how you handle that material. So I really do appreciate you being here today, and all the panel members, thank you for what you're doing in service to our country. And the meeting is adjourned. Thank you.
Thank you.
Thank you. Good job. Nice working. Yeah, nice work.